Who are my heirs? Hi, I'm Darren Findling of the Probate Pro, and we're going to cover the concept of heirs, H-E-I-R-S. When you die with a will, we say you died testate. If you die without a will, we say you died intestate. And what we're referring to are the intestate heirs of the person that died. Why do we care who is defined as an heir and who's not defined as an heir? Well, being an intestate heir gives you authority and standing within a probate estate to receive notice of the pleadings, and most importantly, gives you a right to inherit the assets of the decedent, assuming there's no will. So, in a traditional sense, if you die with a spouse and 2 children, those would be the heirs of the decedent. Those people would, as next of kin, have the right to receive the inheritance from the person that died, as well as, of course, the right to receive notice of all the probate pleadings. So this issue of heirship can become quite complicated because we know that most families are not traditional with a spouse and 2 children. Most families are a mix of blended families, half-siblings, step-siblings, some people who have died before the person that the decedent died. So we have predeceased heirs, and it becomes quite complicated. So we have a formula, a table that describes under each circumstance who is an heir of the decedent, and then what is their corresponding right to inherit based on their level of heirship. That's why it's so important to do your estate planning, because people make presumptions that if they die, their assets will go a certain way, and they may not understand how Michigan statute defines whether someone has a right to inherit. So we strongly encourage you to work with a skilled, competent probate practitioner to plan out your estate plan so that you don't have to rely on the statute. You get to control how your estate is distributed. The part that becomes quite complicated is when there's a post-deceased heir. You may say, well, that's odd. Why would that occur? Well, often people don't open the probate estates immediately. They may wait many, many, many years after the person has died to commence the probate estate. This often occurs when there's a house involved and a family member continues to reside in the house years after the person who owned it died. And then they go and they want to refinance, or they may want to sell that house. And now they're confronted with opening the probate estate and having to get the property from the person that died to the heirs at law. If some of those heirs at law have now died, their interests don't just vanish. It doesn't just disappear into thin air because of their death. Rather, their probate estates become the owner of their share. So it can become quite complicated. You may not just be opening up the original person's probate estate. Now you may have to open up post-deceased probate estates to be able to address the ownership of the real estate. So there's a great benefit of dealing with these types of issues early on. If you've got questions about probate-related issues, visit us at theprobatepro.com or call us at 1-833-PROBATE.